The 1988 murder of two young policemen in Melbourne is infamous in Victoria, and police say it will be the first case reopened if the state's double jeopardy laws are changed. Reform of the laws was among the promises the coalition in Victoria made before taking office. While the police are keen to reopen cases like Walsh Street, the state's legal establishment isn't so sure. Hamish Fitzsimmons reports from Melbourne.
Double jeopardy means if you're acquitted of a charge, you can't be tried again on the same allegations. It's one of the oldest rules of common law, but state governments across the country feel double jeopardy is in need of an overhaul.
It's been made clear that where there is evidence of a perjury, for instance, and just use the one for instance, that there is grounds on a principled basis to look at the double jeopardy situation.
The legal establishment is cautious about the Victorian government's proposal to change double jeopardy laws, and only for certain cases.
For instance, if there's been perjured evidence that's given rise to an acquittal, where there's been some perversion of the course of justice, concoction of evidence, tampering with a jury, or where there's been the bribery of a judicial officer, that might form the basis of a retrial.
One of the most emotive cases cited in the push to change Victorian law is the 1998 murders of two young policemen, Steve Tynan and Damien Eyre, who were shot in cold blood in what became known as the Walsh Street killings. 4 men were tried, then acquitted of the murders. For the Victoria Police, the Walsh Street case remains at the top of its list if the laws change.
In terms of using this legislation, this is our highest priority. There's no question about that. The murder of police in any society, and I believe, goes to the heart of the criminal justice system. And it's not only an investigation that is very important for this organisation, but for the entire Victorian communities.
3 of those acquitted in 1991 are still alive, and last year one of them, Peter David McAvoy, was arrested on separate charges, where it was alleged he made statements implicating himself in the Walsh Street killings. Victoria's top cops now believe they can convince the Director of Public Prosecutions they have sufficient evidence to warrant a new trial.
There's fresh evidence, but we need to be fully exploring that, and we need to do it at the right time so that we don't put in peril a potential retrial.
The state government acknowledges Walsh Street has been the trigger in the push for change.
I think it's fair to say that it's certainly been a focus of attention in all of those issues and considerations over a number of years.
Victoria and Western Australia are the only states yet to reform double jeopardy laws. Last week, the West Australian government introduced legislation that would see someone retried if new or compelling evidence was uncovered. But senior lawyers say that's not sufficient reason for a retrial.
We think there needs to be finality in cases with very narrow exceptions in terms of the way I've described, and new and compelling evidence should not be the basis. There are no examples that have been brought to our attention that show that a case should be reopened on the basis of new or compelling evidence.
Victoria will introduce its laws to Parliament later this year. Hamish Fitzsimmons, Late Line.